afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today we have Janet Coleman presenting for us. If you are unfamiliar with the format of this event, first, Janet is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Janet will go over this in more detail, but please remember to keep your questions as general as possible as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Janet to get us started.
All right, thanks, Marissa. Good afternoon, everyone. I apologize, I'm losing my voice again. Just wanted to introduce myself and kind of talk about some general principles before we get into the specifics of the conversation. If you could advance the slide, please. So what we'll be talking about today is just an introduction and then common end-of-life planning documents, as well as execution or signing requirements in North Carolina. And again, everything is limited to North Carolina. I don't have any expertise whatsoever regarding other states' law or documentation. Next slide. As Marissa told you, and I told you, my name is Janet Coleman. I am a staff attorney with Legal Aid of North Carolina and specifically with the Senior Law Project. We are a division of Legal Aid of North Carolina that serves clients 60 and over. As it says, I grew up in Rhode Island. I moved to North Carolina and attended college at Davidson College in Davidson, North Carolina, and Campbell University School of Law. And I have had a number of hats in my legal career, but I've been with Legal Aid since March of 2022. Next slide. As Marissa and I have both said, we can only provide general information during that question and answer period. We cannot provide specific legal advice for your specific situation, and I apologize. However, there are ethical and other obligations preventing us from doing so. And the laws of other states may be different, so please keep in mind that we cannot provide any information or talk about anything regarding other states' law. Next slide, please. Legal Aid of North Carolina, for those of you who don't know, is a statewide nonprofit law firm. We provide free legal services in civil matters only. We do not represent clients in criminal matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. Next slide. Some of the common cases that we handle throughout Legal Aid of North Carolina include obtaining domestic violence protective orders to protect survivors of family violence, helping tenants fight evictions, fighting illegal termination of public benefits, such as food stamps and Medicaid. Social Security benefits are included in that, assisting homeowners in foreclosure, stopping illegal debt collection, and there are a number of other matters that we also assist with. So I'm going to talk a little bit in general terms about the common end-of-life planning documents, and those include the big four, as we put it, and that is the will, which is the document that controls things at the end of your life. Financial powers of attorney, sometimes referred to as just a power of attorney or a POA. A healthcare power of attorney, also referred to as a healthcare HCPOA, or healthcare power of attorney is more general. And then a living will or advance directive. Next slide. So a lot of people say, well, why do I need these documents? One of the many reasons is that They can be helpful to you and to your loved ones if you become sick or you become incapacitated in some manner. That could be that simply that you are hospitalized, that you become incompetent, that there are things that you are unable to do for yourself. They can also help make sure that things happen the way you want them to at the end of your life and after you have passed. These documents can be especially important if your biological relatives are not the people that you want assisting you in an emergency or inheriting your property after you pass. Next slide. A will is a legal document that sets out who inherits your assets after you pass away and who is to manage the property until it is passed on to your heirs. It states who gets those assets, your real estate, your car, your money, jewelry, other personal property after you die. It also sets out who handles the paperwork to make sure that those people indeed do get the property that you want them to have. Next slide. A will takes effect only the day you die or afterwards. So it has no effect and no meaning until the day that you pass away. So you could technically, as long as you're still mentally competent, change your will every day of your life if you wanted to. As a practical matter, it might not be a great idea. But the only will that would be followed is the last one that you executed before you passed away. A will does not transfer any ownership interest while you are still living. So for example, if you have created a will that says your house will go to your daughter, you can still sell your house and your daughter just won't get anything. It doesn't mean that your will is invalid and no interest is transferred until the will is probated or admitted to court and a formal proceeding is held. Next slide. If you die without a will, your property does not automatically go to the state. Some people think that, but that is not true. Your assets passed by North Carolina law. Those are called the laws of intestacy. Most states do have those as far as I know. However, we have specific ones that are specific to North Carolina. Basically, if you do not have a will, your assets will go to your closest family members, but only through legally recognized relationships. Exactly who gets your property depends on a lot of factors, such as the makeup of your family, how your assets are titled, because some assets may pass outside your estate, outside your will. And so those things could change what happens if you don't have a will, but you might still have, say, a bank account that is titled payable on death to someone else. So that's not going to be part of your estate. That will automatically pass to that person. Or you have a life insurance policy and it's already payable, excuse me, to someone else on your death. It's already been named as a beneficiary. They already have been named, or a pension or things like that. Those are contractual arrangements. So those things go regardless of whether you have a will or not. You would want to speak to an attorney about your specific situation in order to determine what would happen if you do have a will or do not. Next slide. And so one of the things we want to caution you about is we don't want you to be confused about dying without a will and think that that is something that affects Medicaid, because if you owe money to Medicaid for long-term care, they can sometimes go after your property after you pass away. They have what's called a lien on your property, but this has nothing to do with whether you have a will or not. It has more to do with the value of your assets and also the value and how they've passed, and also how much care they've provided and need to recover. Medicaid estate planning is very complex, and you would again want to speak to someone who is a qualified attorney as to whether or not you need to be concerned about those things. Next slide. So some Some folks have minor children or they have disabled adults that they have guardianship over. In your will, you can actually nominate someone to become the guardian of that minor child or disabled adult over whom you have guardianship. That declaration in your will, that statement in your will, is not binding on the court, however, is probably going to be very persuasive to the court appointing a guardian for that person. You can also create what's called a standby guardianship. This is not done in a will and it cannot be done in a will. However, it does set someone up in advance to be a guardian over a minor child or a disabled adult. It is done during your lifetime through a petition in front of the clerk of court in your county of residence. And it does require that the parent or guardian have a fatal or progressive chronic illness. And you would have to provide documentation of that in order to set up that standby guardianship. Next slide. So people ask, what is a financial power of attorney? And sometimes people get confused about powers of attorney and think that they're still valid after the person who created it passes away. And that is not true. They are only valid during your lifetime. And when people use that term, power of attorney, usually they mean the one for financial affairs. The financial power of attorney is a document that names someone to help you out in financial matters, dealing with taxes, paying bills, litigation, caring for your house, your person, things like that. The person that helps you out is called your agent, although a lot of people use the term power of attorney or POA for the actual person. So for example, someone who is your agent or power of attorney, if you had an unexpected accident and you go into a coma, your agent could call your mortgage company to ask if your payments have been made and then write a check to make your payment if that becomes necessary. Those are the types of things that an agent or a POA would be able to do. Next slide. They can write checks from your bank account. They can transfer money from your savings to your checking. They could call your car insurance company to cancel your car insurance if you're no longer going to be able to drive and don't need to insure the car, or call to make sure that your tax office, call and see if your taxes have been paid, and then make a payment for them if necessary, buy or sell assets, handle a lawsuit on your behalf, things of that nature. Next slide. When does a power of attorney take effect? Well, there's a couple of different times or ways that they become effective. You can choose to have your agent be able to help you immediately. It does not mean that you cannot act for yourself. It's basically you both have authority to act. So they could do it if necessary, but you could also still do it. Or only upon some future event, such as if you become incapacitated and can no longer handle your financial affairs yourself. That's called a springing power of attorney. The other one is effective immediately. Both of those typically you would want to be what is called a durable power of attorney, which means that it lasts in case you do become incapacitated. Next slide. So there are some limits on the agent. Even if the agent is given access to your finances, they are required to use your money in a way that benefits you and you only. For example, they may have the authority to write checks from your bank account, but they should not be writing a check to pay their own cell phone bill. Next slide. However, we want to warn you that a financial power of attorney in particular creates the potential for financial abuse and exploitation. It does give someone access to your money. They are not supposed to use this access to benefit themselves, but that does not mean it doesn't ever happen. And so we always caution folks when we are creating powers of attorney for them that you want to be extremely careful in who you pick to be your agent under a power of attorney, because they do have, in essence, the same authority to act on your behalf or with your assets as you would have. And they may or may not be always mindful of the fact that it is only supposed to be used for your benefit. Next slide. There's a difference between a power of attorney and a guardianship. A power of attorney by itself does not take away any of your own decision-making power. You still maintain the rights to make your decisions about your assets as long as you're competent and not incapacitated. And you also make the choice of who you want to serve as your power of attorney. However, if you're declared incompetent by a court, the court will decide who has decision-making power and what specific powers they will have by appointing a guardian. And the powers of the guardian will be specifically described in the appointment document. That is a court form that the clerk of court, who is the court that makes decisions regarding guardianships and guardians, will be listed in that document. So the powers of the guardian are listed. However, in a power of attorney, you decide what powers your agent will have. So there's a very discrete difference, a distinct difference between those. Next slide. So we get the question a lot, how do I get a power of attorney over mom? And the answer is you cannot. Only the principal or the person who we are helping, an attorney in general, not just legal aid, can execute a power of attorney. So you as a adult child cannot go to an attorney and say, I want to get power of attorney over my mom. It doesn't work that way. An agent cannot execute a power of attorney on behalf of someone else. And if the principal is unwilling or unable, such as being incompetent or unconscious, to sign that power of attorney, then there is no way to get one. The helper that must then seek guardianship, which requires a court order declaring incompetency. Next slide, please. So then you have what is called a healthcare power of attorney. This is a document that names someone to make your medical and healthcare decisions if you are no longer able to make those decisions yourself. So unlike the financial power of attorney, where you can make it effective immediately, a healthcare power of attorney only becomes effective in the event that you are no longer able to make those decisions yourself. For example, if you have a car accident and are unconscious, your healthcare agent could decide if you should have surgery right away or if it's desirable to wait, and they will make those medical care decisions for you because you're unable to do so for yourself. A physician actually determines whether or not the healthcare power of attorney comes into effect, and they make that decision based on their medical opinion of whether or not you are able to make those decisions for yourself. Next slide. There are a number of different kinds of decisions that your healthcare agent can make. For example, they can request and review information about your medical condition and consent to its disclosure. It allows them to, in essence, bypass HIPAA requirements. They can also hire and fire healthcare providers. They can consent to and authorize your admission or discharge from various healthcare or mental health care facilities. They can consent to and authorize the administration of medications, surgery, x-rays, anesthesia, etc. for you. It can authorize the withholding or withdrawal of life-prolonging measures, and they can authorize an autopsy of you or direct the disposition of your remains. Basically, any medical decision that you could make for yourself, that healthcare agent can make, unless you put limitations in that healthcare power of attorney. Next slide. The difference between the financial power of attorney and the healthcare power of attorney is that the financial power of attorney deals only with financial matters. The healthcare power of attorney deals with healthcare and medical matters. So having only one of these does not give your agent authority in the other arena. So for example, your agent under the healthcare power of attorney could not close out your bank account for you, could not pay your bills. They can only make decisions dealing with healthcare and medical matters. Next slide. As I said a moment ago, unlike the financial power of attorney, The healthcare power of attorney only takes effect if and when you are no longer able to make your medical decisions yourself. As long as you're able to make and communicate your own medical decisions, your doctors always will go to you and only you. Next slide. A living will is a document that tells your doctors that if you are getting towards the end of your life, you do not want certain extraordinary life prolonging measures to be utilized in certain scenarios. Those measures include putting you on a ventilator, putting you on life support, things like that. It is also called an advance directive for a natural death. Next slide. The difference between a healthcare power of attorney and a living will is that a healthcare power of attorney names someone else to make your medical decisions if you can't make them yourself. A living will or an advance directive expresses your own wishes for your end of life care. There is sometimes some overlap, but it's not perfect overlap. So for example, someone may have dementia for years, so they need a healthcare agent to make everyday healthcare decisions, but they aren't necessarily at the end of their life. So the living will is not going to come into effect because they are not at that terminal stage. They just need assistance with those healthcare decisions on a daily basis. Next slide. There is a difference between a living will and a DNR, or do not resuscitate order. That is a medical order which must come from a doctor. A living will is a legal document that you execute yourself, probably and definitely should be with the help of an attorney. An attorney cannot give you a DNR order. Only a doctor can do that. Next slide. A living will only takes effect under specific circumstances that you choose. You can choose those specific triggers in your own document. The 3 choices include that you are suffering from an incurable or irreversible condition that will result in your death within a relatively short period of time, or that you are unconscious and the doctors providing your care believe to a high degree of medical certainty that you will never regain consciousness, or that you suffer from advanced dementia or any other condition resulting in a substantial loss of your cognitive ability, and that loss to a high degree of medical certainty is not reversible. You can choose any or all of these 3 triggers. Next slide. In order for these documents, and that is relative to all 4 of what we've talked about, to be valid, they have to be executed or signed by the maker and others in a way set out by statute. It is a formal process. So if, for example, you email your neighbor and say to them, I want you to get everything, that is not going to be enforceable by the courts. It would not transfer title to your assets when you pass away. Or grandpa drives granddaughter around his farm and says, this will all be yours someday. Again, that is not a valid will. It is not enforceable in a court in this state particularly. Again, I can't speak to other states. Next slide. For a valid execution, there are certain requirements, all but the financial power of attorney require 2 witnesses. It must be signed by the person who makes the document. In other words, the testator in a will, the principal in a power of attorney. It must be signed by 2 disinterested witnesses. And in the case of a healthcare power of attorney, they cannot be employees of the healthcare facility where you are located. For example, if a person is in a nursing home and wants to sign a healthcare power of attorney, they cannot have employees of that healthcare facility as witnesses on their power of attorney. And that is in the statute. Also, they must be acknowledged by a notary. In the case of the financial power of attorney, it only requires that it be signed by the principal and notarized. No witnesses are required. Next slide. So a lot of times we get questions regarding handwritten wills, and people say, can I just write my will out? The answer is qualified, yes. Handwritten wills are called holographic wills. This is an option if you cannot get to an attorney to prepare a will for you right away. However, it should be a temporary stopgap solution, and you should go to an attorney to have a will prepared properly as soon as it is feasible to do so. Next slide. Requirements for a valid handwritten or holographic will are, in North Carolina, that they must be written entirely of the handwriting of the person making the will. So in other words, you can't type it up. It has to be handwritten. It has to be signed by the testator, the person making the will. It must be found in a proper place, such as in a safety deposit box or with the testator's important papers, or they've given it to someone for safekeeping and asked them to maintain that for them. After death, in order to probate a handwritten will or a holographic will, there must be 3 witnesses that can testify that that is the testator's handwriting, and at least 1 witness must be able to testify to the court that the will was found with the important papers of the testator. So there are some additional requirements for those holographic or handwritten wills to admit those to probate. If you want to write a handwritten will yourself, keep it really simple is the best advice. Distribute that property, whatever you're doing. I see a typo, sorry. Distribute the property clearly with no conditions. So say something to the effect of, to all my children equal shares, instead of to my son, but only if he has graduated high school and had children. And if he has not graduated, then property is to be given to the Humane Society, but only if it is run as an animal shelter. And if it's not, then it's to go to the X, Y, and Z. Identify the property clearly in a way that even a stranger would understand, such as number and street name, such as 136 Oak Street, rather than the old home place or the mountain house. You may know what you're talking about, but the court does not, and it has to be clearly designated in order to be valid. Next slide. And remember, again, that a will is technically a financial transaction. So you want to state who you want to receive your assets in simple terms. Save statements like how much you love your family or the person you're giving that property to for other means of communication, such as a separate letter that you can attach or include. In the same way that you would not add emotional notes to a car title or a real estate deed, please leave these off of a handwritten will. Next slide. There are a number of additional resources available in addition to this presentation. You can go to lawhelpnc.org. You can look at the North Carolina Courts website, which is nccourts.gov. They do have a number of things regarding wills and estates, and actually have some manuals that they've created online with the forms, so that if you have to probate a will or become an administrator or an executor of a estate, you can look those up. The Secretary of State has forms regarding healthcare powers of attorney as well as living wills, and you can actually register those documents with the Secretary of State. You can look at the Secretary of State's website, which is sosnc.gov. You can also look at Chapter 31 of the North Carolina General Statutes, which discusses wills and when they are valid and various other legal requirements. Chapter 29 of the North Carolina General Statutes regards intestate succession. That is when you don't have a will, how your property passes. And I can't even begin to go through all of that today here, because it would take at least an hour to go through all of that. But there are sort of lines of succession. Go to your children first, then to your siblings and your parents, and then it goes out to cousins and aunts and uncles, and it gets pretty complicated if it goes out that far. And lastly, Chapter 32C, which is the Uniform Power of Attorney Act, and that is what governs financial powers of attorney. We've also got our phone numbers listed on that slide, as well as our website, which is www.legalaid@sea.org. And that is the end of my presentation, so we can take questions.
I'm not seeing any questions in the chat right now. Again, if you have questions, you need to post them in the Q&A box on Zoom or the comment section on Facebook. Gonna give it just a moment here to see if any questions come in. Uh, would a valid will of another state still be valid in North Carolina?
It can be. I can't say yes or no. One of the requirements in North Carolina for a will executed in another state to be valid is that it comply with our requirements. So it would need to have witnesses, notarized, things like that. But yes, often people don't change their wills and they're often admitted to probate without any difficulties.
Okay. Next question. Would say something like a POA, created properly in North Carolina, be good in another state or principality, like Puerto Rico or something?
So we attempt to do our forms, and I would expect most attorneys do, in North Carolina, attempt to make them valid no matter where they're used. And then we do actually have provisions in our templates that we use for those, which are actually the statutory forms that make them, we attempt to make them valid. Every state, however, has different requirements for things, as I just discussed. And so we hope that they will be valid, but we cannot promise anything because we are not licensed to practice in other states. And I don't profess to be an expert on anything other than North Carolina law.
Good. Those who are asking about assistance with creating this document, someone is specifically asking about seniors. If you look at the bottom of the page here, and I will also post a link in the chat, you can reach out to the Legal Aid of North Carolina Senior Helpline for seniors looking to potentially obtain some of these documents. So I answered that one, and I will be putting that link in the chat shortly. Someone's asking about how many times would you say someone meets with an attorney to establish these 4 documents?
It really depends on the complexity of what they're trying to do. That's a really difficult question to be specific about because it could be as simple as maybe an hour conversation prior to meeting and then going over the documents and signing them. And that would take, say, another hour, or it could be several hours, or it could be longer. It really just depends on each individual situation. I won't say it's weeks or anything like that because it can be a fairly quick process. But again, that depends on what they're trying to accomplish. If they know what they want to do, sometimes with clients, I will have to talk to them several times because they don't think about these things in advance, like what's required, what they're going to have to make decisions about, and then they have to think about it or to speak to people. We do encourage you, if you're asking someone to be an executor or to be a power of attorney, whether financial or otherwise, that you talk to the people that you're naming and make sure they're willing to serve in that capacity. So maybe they haven't done that yet, so it takes a little longer for them to accomplish that.
Got you. Could a beneficiary identify the handwriting in a holographic will?
I'm sorry, what?
Could someone who's beneficiary under a holographic will kind of identify or verify the handwriting?
I would say yes. I don't know the answer to that question, but I would surmise it is yes, as long as it's someone that is familiar with their handwriting. I have never, ever seen one, a holographic will admitted to probate, and I've been practicing law for 40 years. So I don't know the answer to that question, but that's just a guess.
Okay. Not sure if you're gonna know the answer to this one. Would a will be used to have the beneficiaries of a 401 notified?
I'm sorry, say that again?
Would a will be used to have the beneficiaries of a 401 notified? I don't know what that is.
So I'm assuming, and maybe the person who asked the question can clarify a little bit, but I'm assuming you're asking if a will is used to notify beneficiaries of a 401k
Oh,
that they are
maybe.
inheriting property? Is that the question?
Maybe. I just hold on. Yes, that is the question. Person just said yes,
Okay.
that's the question.
Okay. No, the answer is no, because a 401k, as I said earlier in the presentation, is similar to a bank account in that you designate beneficiaries with the entity that is holding that 401k account. And that is something that passes outside of your will or outside of your estate. It's a contractual arrangement, so it would not be used for that purpose.
Gotcha. Do you have any recommendations for low-income seniors seeking to establish these documents who don't speak English or Spanish, or that's not their main language, one of those two?
Yeah, we have that question come up occasionally. We do have, I think it's called Language Line, and it is something that we can utilize to speak with clients who do not speak English as their native language or Spanish. There's a lot of different languages that they can provide. It is a little more complicated, obviously, to do it that way, but it is available.
Do stepchildren have rights when they're not expressly written in the will?
Oh, wow. That's a hard question.
That's a,
So
yeah,
if there's a
have to do
will,
directly.
then obviously people can always contest a will if they're written out of the will or not included in the will. However, if there is a will, you designate who you want to get your property in that document. If there is not a will, then I do not think, and I'd have to do some research on this, so I can't answer specifically, but I do not think that stepchildren are included in intestate succession rights because they are not, unless they've been adopted.
I'm pretty sure that's correct. What do you think of the online tools for creating a will?
I recommend not using them. The problem I've seen with people trying to use them in the past is that they are not necessarily geared to North Carolina. They may be forms that are created in other states, and the documents actually say it on the forms, but people don't necessarily see that. Plus, there may be things that you need to discuss with an attorney that you're not going to have the availability of doing that. You know, if you're getting a form online, you're not going to have someone to talk to about what is right and what is wrong, and whether this is going to be a valid will in that particular state.
Does the financial institution determine how a check would be written by the POA? I guess.
I don't know the answer to that one. I would say that would be dependent on the financial institution. I can speak from personal experience in that I am a power of attorney for my mom, and I just signed my name. But you can put your name, POA. I mean, there's different, it really depends on what the bank requires. Although it's been my experience that banks will typically, if a check is signed and there's no obvious issues.
Gotcha. What's the difference between wills and trust, and when do you need each one?
I'm sorry, what's the difference between wills and trusts, and what was the second part of that?
And when would you need each one? Like, when do you need a will? When do you need a trust?
Well, we don't do trust at Legal Aid, because there are many, many, many different kinds of trusts available to be drafted. There are revocable trusts, irrevocable trusts, living trusts, testamentary trusts, which are trusts created by will. We don't do those either. And so I can't speak to when a trust is appropriate or inappropriate because we don't create those. You would definitely want to have a private attorney who is knowledgeable in how to determine what best suits your needs in that particular instance. However, will is only effective upon death. A trust can be effective during your lifetime.
Can you explain a little bit and talk about the role of the executor? What does the executor do? Who is that?
The executor is the person who makes sure that your wishes as expressed in your will are carried out. They are appointed by the court, as is an administrator. So for example, if there is no will, then, or the executor is unable to serve, or for example, has already passed away, and maybe you didn't know it, then the court will appoint either an administrator or an executor. They have similar functions and similar powers. What they are required to do is to notify creditors of the decedent, the deceased person, that the person has passed away, and there are certain legal requirements where they have to put notice in the newspaper to make sure that people know that that person is deceased and to file their claims with the estate. They have to distribute the property. In the meantime, say an estate is going to have to be open for some period of time. Maybe there's litigation involved, then they would also have to keep the estate open, file certain accountings with the court, with the clerk of court. And I can tell you that the clerks of court are very diligent about making sure that gets done in a prompt manner. They will send you notices, and they are get increasingly demanding about the fact that you haven't done it yet. And they just in general administer the estate, make sure that the property is distributed in the manner that either the law requires when there is no will, or that the will requires or dictates.
If someone doesn't have a beneficiary, blah, la, 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 la. If someone doesn't have a beneficiary for their retirement or their bank accounts or other things, does that become a part of the assets?
Yes.
Okay. That was the whole question. Okay, next one. Can the executor also be a beneficiary?
Yes.
All right.
Some of our clients only have one child, and they want everything to go to their child, and that child is also named as the executor. There's no conflict whatsoever. Of course, we would not want to have them be a witness, but other than that, there's certainly no conflict between them serving all those roles.
Is it a good idea to have a backup or a contingent executor?
We do recommend that, yes. It's not necessary legally, but we do recommend it as a practical matter. Sometimes the person, you might have asked them at a time when they were vulnerable, and they said, sure, I'll do it. And then they realized life has got in the way and we can't serve that in that capacity anymore for some reason. So it's really a good idea to have someone else, but again, not required.
Gotcha. And I know you mentioned your feelings online, but can you use a will or power of attorney that was online and just have it notarized? Can you still use them, even if not recommended?
A will would have to be witnessed, your signature and notarized to be valid in North Carolina. You can certainly use those forms, as well as the power of attorney is available online, and that is a North Carolina statutory form. So it's not something that, if you look at the power of attorney statute, you can find that form. Again, I don't recommend using that without consulting with an attorney, simply because there may be things that you want to limit that you don't realize that you should limit without discussing it with an attorney.
Can you have co-executors?
You can. We absolutely don't encourage that, simply because in the event that there is a disagreement that creates havoc, if they are not to agree on what is supposed to happen, and then the clerk ends up having to resolve disputes, which the clerks don't like to do. So I would discourage it for that reason. It's not impossible and it's not against the law by any means. It can't be done. Absolutely we will not, I will not personally prepare a healthcare power of attorney with two agents, because that is where things could become life-threatening if they can't agree. And so I simply won't prepare those. And I think that's the policy of our whole firm, but, I think most attorneys would feel that way, but it is possible to have co-executors. Again, not necessarily recommended.
Does legal aid review these documents that were prepared, if they were prepared, under the validity of another state, to see if they're valid in North Carolina as well? Is that something legal aid would help out with?
Good question. I don't know. I would say yes, maybe. I mean, certainly if you qualified for our services and said, I want a will, and then you said, well, I already have a will and I think it might be okay, we look at it, we could do that. Most likely we would want to prepare a new one, however.
And then does the executor have the same abilities as a financial POA relative to bank account access?
Well, I mean, they're apples and oranges. Power of attorney, financial power of attorney only has authority during the lifetime of the principal. And an executor only acts after the death of the principal. So yes and no. They're not really, there's just not even the same creature. One is only acting during the lifetime, one is only acting after the death. And after the death of the testator or the person who made the will, there's no need for them to pay the daily bills because that person is no longer with us. So they're paying the bills that were incurred prior to death, and then maybe things relating to the administration of the estate. Or perhaps if there's a house that's to be sold, they may have to pay taxes and insurance on that house while it's being sold. Sometimes there's a provision in a will, for example, that you would say, I want to have my house sold and the proceeds divided among my 4 children in equal shares. Well, the executor is actually responsible for selling that house, and they're also responsible for maintaining the property until it is sold, and then for distributing the proceeds. So they're a little different scenarios, but yes, they're similar and yet different.
Okay. I think this question is asking, before a will is executed, if there are changes needed to things such as insurance policy, beneficiaries, should that happen before a will is executed, like changes to other things? I think that's what the
It
question
really
is.
doesn't matter so much, but I mean, my philosophy on that is if you're doing a will, you want everything to be kind of organized as of that day, so that if something were to happen to you the next day, everything's taken care of and you have it the way you want it to be. So I encourage people, if they're planning on making those changes, to do those as soon as possible. It doesn't have to be prior to the will execution, but it should be as soon as possible.
Okay. And then the last question that I'm seeing, someone is saying that they actually had a will made with legal aid some time ago, and now they can't find their copy. Would legal aid have a copy of that document?
Most likely not, unless it was done very recently. We've only recently begun keeping copies of the signed documents. However, a copy is not valid for admission to probate, only the original is. So We do provide instructions to our clients when they sign a will as to where they should store it and how to get access to it. We would always have a copy of the draft, but not necessarily a signed copy.
For those of you who are looking for assistance from legal aid, you need to apply. I have put the link to legalaidofnorthcarolina.org/get-help where you can apply online, or it has our phone number, as well as that information is also available on the screen for you. For those of you looking to apply. One check, I am not seeing any more questions except for the questions about the slides, which I'm about to address in a second. One last check here. Okay. And so since I am not seeing any more questions, I'm going to go ahead and say thank you all for joining us, with a special thank you to Janet for presenting and for answering all those questions. If you would like to review anything we talked about today, we have posted a recording of today's event to our Facebook. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen to Learn presentations that Janet mentioned, such as tenant rights, Medicaid, Social Security, child custody, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.
Thanks, everybody.